So, what just happened and what's likely to happen next? What are you talking about, Al? I am talking about this permission to appeal application regarding the injunction stopping the Bell Hotel from housing migrants. And notice there I said permission to appeal, not actually a full appeal. So just to go back to the start, as you may know, the particular hotel was being used to house asylum seekers and, other people, sort of migrants. I don't know what the correct, the entire status was. But the local authority applied for an injunction to prohibit that. And they principally did it on the basis that it was a breach of planning regulations on the grounds that the planning consent for the building was only permitted for hotel use, and actually housing asylum seekers does not fall within that. So they applied for an injunction, and they applied for a permanent injunction, saying that the hotel just cannot do that forever. But the full hearing had not actually been heard. However, what you can do is, if you're applying for a permanent injunction, you can, at an early stage, say, well, look, can we have an interim injunction pending the resolution? And what the courts do there is they apply something called the American cyanamide test. Now, I won't go into full details about that, and I've done other videos about it, so just Google injunctions and super injunctions, and I go into lots of detail. But in applying for an injunction, you have to show certain things, like damages won't be an appropriate remedy. Well, this is clearly not a financial thing, because the argument is it's causing disruption, and it's causing problems, and it's causing protests and all that sort of thing. So it's not like saying, well, we didn't give you an injunction, but you can have some money to make up for it. We apply something called the balance of convenience test. We look at, well, let's say we decide to grant the injunction, and it turns out down the line that we shouldn't have done, versus we decide not to grant the injunction, and down the line it turns out we should have done. Who would lose out the most? So it could be, say for instance, it's an injunction to prevent, chopping down a tree. Well, the argument there is, if we grant the injunction in error, and it turns out down the line you were entitled to chop down the tree, what have you lost? You've had a tree there for a few more weeks or months, so big deal unless it was causing any sort of major disruption. But what if we say you can chop the tree down and then it turns out we're wrong? Well, it's not like you can make the tree grow back. So that's the balance of convenience test. And in this particular case, they applied the balance of convenience test, and they applied for an interim injunction, and they were granted it. But like I say, that was pending the full hearing. So what's this appeal about, or this permission hearing? Well, it's brought on behalf of the Home Office. And what they're saying is, well, at the original hearing, we were not heard. And we had a right to intervene. So I need to briefly explain what intervention is. This applies especially in judicial review proceedings, public law proceedings, although it can actually apply in all civil proceedings. But for now, I'll just look at the judicial review. So what people could say is, well, look, we have an interest in being heard. We can actually add to this debate. We can bring something to it that we think you need to consider. And the test for allowing an intervention, it's just that, is it desirable? That's it. Is it desirable that the intervention is allowed? And what can interveners do? They can make legal submissions, so they can say, well, we're not commenting on the evidence, but having heard all the evidence, here's a little legal submission on our behalf. So we're not, the applicant and the respondent can make their own legal submissions. We'd like to make our own. I mean, in America, they call that amicus curiae. And I've spoken before about, I've been involved in a few amicus briefs in the US. I mean, technically they're amicus briefs here, but we just call them interventions. Can you actually put in your own evidence on an intervention? Yes, you can, but you need the permission of the court. So you can say, we would like to make some legal submissions, and also, so here's some evidence that neither side have put in, but we think it would be helpful. You need to apply at a very early stage to intervene, because if you sort of go, oh, we've only just found out about this, or, can we do it now? The courts are very reluctant to say, well, we'll adjourn the hearing, because obviously it's not just a matter of saying, well, we're ready now. You've got to serve all your material on both sides, so they can actually, look at it themselves and take that into account. But what was this appeal about? Well, like I say, it was a permission to appeal hearing. So what the Home Office said is, we should have been allowed to intervene. And the reason we didn't intervene is the council didn't tell us that they were doing this. And that's where the judge was sort of quite critical. the appeal court judges, they're saying actually the first instance judge, and it is actually quite a robust criticism. Now people always say, oh, the judiciary always stand up for each other and they always have each other's backs. Well, I think this is an example to show that no, they don't. I mean, the appeal court has been very critical of the first instance judge and of the council, because what they're saying is, look, you should have known that the Home Office, who are in charge of all this sort of thing, and they're the ones putting people in these hotels, of course they might want to have a say about it. So you should have given them a heads up, saying, just to let you know, we're applying for this injunction, it might be you want to apply to intervene. So that's what they've been knocked back on. So what have they actually allowed? Well, they've said, okay, we are overturning the interim injunction. We think the judge got the American cyanamide balancing test incorrect. And actually, rather than just turf out hundreds of people that all of a sudden the Home Office have to, find somewhere else for, it's probably better that we let people stay there. Because, like I said, the full appeal's coming on mid-October. So it's probably best to let people stay there for another couple of months because, is it going to make the situation any worse? Well, there's all the protests, but they're already there. So it's probably better. Because another thing is with injunctions, if it's very finely balanced and you can't decide, which way it should go, then you just leave the status quo. You just leave things as they are. So that's what the appeal court have said. They have said, right, we'll overturn the injunction. Let's just leave things as they are at the moment. The full hearing is going to happen in mid-October, at which time that gives plenty of time for the Home Office to put in their submissions. So it's not like... it might be down the line that at the full hearing they say, well, actually, having considered everything and having considered what the Home Office themselves say and all their stuff, actually, we agree with the original decision, and we think actually, yes, an injunction should be granted, and we're going to make a permanent injunction. So that's the situation now. So basically, injunction overturned because it was a temporary injunction. So the status quo maintains, but there is to be a full hearing in October where the council can still apply for their permanent injunction, but the Home Office to get to chip in with their things. And I've seen a lot of misreporting. I mean, the bits about, it was argued on behalf of the government that the rights of asylum seekers trump the rights of local residents. I can't see anywhere in any of the application, any of the arguments where anybody ever raised that, so I'm not quite sure where that's coming from. I mean, if somebody can get hold of a transcript or get hold of the submissions, I'll have a look and just see what they said, but that does seem to be sort of some misreporting, because like I said, this was done on very, very technical grounds. I mean, the whole point of these sorts of hearings are you don't actually at this stage, who's trying to ring me? I'll call them back later. The whole point at this stage is you don't actually argue the full merits of the case. So at this stage it was purely procedural. It's just saying, well, we do need to consider the full merits of this case, and it would be helpful if we heard what the Home Office had to say about that. So that's where we are. So I hope that's made things a bit clearer. Hope you've found that, as always, vaguely interesting, vaguely informative, and vaguely accurate. And I will monitor this, and we'll see what happens in mid-October.